Hi, good afternoon. This is again a very interesting judgment of Bombay High Court. L&T and IHI Consortium, that is the name of the petitioner. So it is a GST judgment. So if you are paying GST, then it is very important for you. Others, if they are not paying GST, they must have some basic tax knowledge. Otherwise, this judgment will be slightly boring. I will try to be make it as interesting as possible and as simple as possible, without leaving the important points of this judgment. So, petitioner, that is L&T and IHI Infrastructure Consortium. So, it is an unincorporated consortium. Unincorporated consortium. They wanted to secure a tender from Mumbai Metropolitan Region Development Authority. So the hereafter I will call Mumbai Metropolitan Region Development Authority as MMRDA. Otherwise, most of the time will go in pronouncing the name itself. So MMRDA is the authority. He floated a tender. It floated a tender for Mumbai Thane Harbour Link project. So this consortium consisted of two members. One is L&T, another is IHI Infrastructure, which is Japan. So it had two members. They jointly formed a consortium and applied for the tender. They were successful in getting that tender. So back-to-back contracts were entered. MMRDA entered into contract with L&T, this consortium. Consortium in turn entered into contract with L&T and IHI. So yeah, the consortium will raise bill on MMRDA. L&T and IHI will raise bill on this consortium. This is the fact. Then subsequently, one more fact is MMRDA paid an advance amount to the consortium and they paid GST also on that amount. The consortium in turn gave this advance to L&T and IHI. Advance. Now, consortium was not permitted by the authorities to take input tax credit. Since section 16(2)(b) says no input tax can be availed unless service is received, because it is only an advance. So no goods are received or no service was received. So they said you cannot avail the credit. Second contention of the department was receipt voucher is not a tax paying document under section 16(2)(a) of GST Act, and hence you cannot take credit. This is the contention of the department. They refused to permit them to take credit. So the consortium went to Bombay High Court. They made the following contentions before the High Court. One, what is received is not an advance but a loan. Hence GST need not be paid on that. That is the first contention. Second contention is tax is imposed on supply agreed to be made within quotes, whereas constitution permits tax on supply. This is the second condition. Very important. Please note carefully. Tax is imposed on supply agreed to be made, whereas constitution permits tax on supply only. Then third, receipt of payment even before providing service is treated as time of supply of service. That is also wrong according to the petitioner. 4. ITC denied until service is actually received. Fifth contention. ITC denied on the ground of receipt voucher is not a tax paying document. That was the fifth contention. Sixth contention was this results in petitioner remitting tax GST at 110% of the contract value. The seventh one was even assuming that refund I am eligible for refund. Refund is possible only in two situations. One is it should be a zero rated supply, or the other is inverted duty structure should be there. That is, tax on input should be more than tax on output. That is not the case of the petitioner. So I am not even eligible for refund. Bombay High Court, the first contention. That is, the first contention is this amount is only a loan and not an advance. That is the first contention. Bombay High Court, on reading the contract, held that the amount received by the consortium is only an advance and not a loan as contended by the petitioner. The advance is in the nature of mobilization advance. This is very, very important. Even if treated as loan, petitioner cannot escape from the clutches of Section 76 of GST Act. That is, suppose if you unauthorizedly collect any amount as tax, even assuming it is a loan, you have collected tax. So government has the power to recover that tax unauthorizedly collected by you. So the High Court said even if treated as loan, petitioner cannot escape from provisions of Section 76 of GST Act. Now, challenge to Section 7 and 9. On consideration of various provisions, Bombay High Court held consideration includes any payment made or to be made. Hence, advance is a consideration for supply of service, according to Bombay High Court. Section 7(1)(a) includes, very, very important, please note. Section 7(1)(a) includes four elements. One, all forms of supply of goods or services or both. One. Two, which are made or agreed to be made. Made or agreed to be made. Two. Three, consideration. Four, in the course of or furtherance of business. Once this test is satisfied, charging section is attracted. High Court noted certain judgments of Supreme Court and held the phrase in furtherance of business would mean that the supply is connected to or in relation to activities in question or integral to such activity. The court held once advance is received in the course of furtherance of contract, it would necessarily amount to supply attracting payment of GST. So once you receive advance, then it will necessarily amount to supply. That is what the High Court says. Then the court says the common thread that runs through section 7(1)(a) and 7(1)(aa) cannot be given a meaning different than what is attributed by Parliament. Court rejected the argument that scope of supply is not applicable to deferred supply. Based on the above reasoning, the challenge to section 7 that it applies even to supplies agreed to be made, this is not correct. They rejected that argument. Then challenge to section 12 and 13. Section 12 and 13 deals with time of supply. 12 deals with time of supply of goods and 13 deals with time of supply of services. The contention of the petitioner was these provisions, section 12 and 13, are invalid as Article 246A read with Article 366(12)A applies in respect of supply of goods or services and not in relation to supply agreed to be made. Similar contention as to section 7 and 9. Once actual supply is not made, this is the contention of the petitioner. Once actual supply is not made, there is no warrant for levy of tax. This was the contention. The court said under section 12 and 13, issue of invoice is not sacrosanct. Provision provides for alternatives also to decide the time of supply. One is receipt of payment, second is your entry in books, provision of service, raising of invoice. But there are alternatives are there. High Court held that constitutional provisions define and or lay down broad contours of the subject matter of legislation. Parliament and legislature can frame the laws and not the actual framework and nitty-gritties of how GST legislation would work post legislation. So they can only frame the law. Broadly, they can define the law. Cannot lay down all the nitty-gritties of this legislation. It is too weak a proposition to negate the validity of GST provisions on this ground. That is what the court said. Then the challenge to section 16, whether petitioner is entitled to ITC. This is the main contention of the petitioner. Because petitioner says, I deposited the GST, but department is denying credit to it. Now, court says, 16(2)(b) says, petitioner must receive goods or services. No goods or services received. No invoice raised. Petitioner contention in this case, because they have not received the goods, they have not received the services, they have not received any invoice. Petitioner's contention was when GST was deposited without receipt of supply and invoice from L&T. Petition was precluded from availing ITC. Hence, it is ultra vires provision of section 13(2). That is the contention of the petitioner. This contention found favor with the High Court. Court held, even though petitioners complied with other provisions of the Act, it was not able to comply with section 16(2)(b), that is requirement of invoice, because they gave only a receipt voucher. On receipt of advance, L&T gave only a receipt voucher with GST. They did not issue an invoice. So, but they have complied with all the provisions of the Act. Petitioner is registered dealer. There was no dispute. Petitioner deposited tax. No dispute. Petitioner was in situation of robust certainty of performance of contract, because contract was entered with to MMRDA. So the performance of the contract is assured. Petitioner is in the process of generating supply of goods or services, not disputed. Except invoice, other documents evidencing payment of GST was available with the petitioner. Revenue authorities should carefully apply their mind in case of peculiar transactions, especially government contracts. This is what the court says. The court says, again, repeat, revenue authorities should carefully apply their mind in case of peculiar transaction, especially government contracts. Section 16(2)(a) permits credit of ITC on any supply of goods or services used or intended to be used in the course or furtherance of business. The basic requirements are specified in section 16(2)(a). Although it is conditional upon fulfillment of section 16(2)(b), the words intended to be used in the course or furtherance of business would mean deferred receipts of goods or services. Then the court says the word used in section 16(1) should be given due meaning when it says credit would be available when goods or services are received. So again I repeat, this is very important. The word used in section 16(1) should be given its due meaning when it says credit would be available when goods or services are received. If not read in that fashion, it will create an anomalous situation or even an absurdity. This is what the court says. On the one hand, tax is deposited. This is not disputed. on intended supply. On the other hand, merely on the interpretation, that is, it is in the process of being received, credit is denied by the department. This interpretation uh, it cannot be accepted. That is what the court says. Because you have to accept, once they have deposited the tax, you must give the credit to them. Otherwise, it will create an anomalous situation or an absurdity. Another hurdle is that petitioner should be in possession of tax invoice or debit note as per section 16(2)(a). Section 31 gives meaning of tax paying documents. Revenue denies credit by reading section 31 with rule 36. The receipt voucher satisfies the requirement of section 31 read with rule 36. Section 31 provides that on receipt of advance payment with respect to supply of goods or services, a receipt voucher containing such particulars evidencing receipt of such payment should be made. The rigor and mandate of section 31(1) and 31(2) are not applicable to section 31(3). This is very, very important. Again, I repeat, the rigor and mandate of section 31(1) and 31(2) are not applicable to section 31(3). It stands on its own legs. So, court held petitioner cannot be denied ITC. So, finally, the conclusion of this judgment is the challenge to the constitutional validity of the provisions of section 7, 9, 13, and 16. All of them were rejected. But the contention of the department that you cannot take credit till you have received the goods or services, or since you are not in possession of a tax invoice, you cannot take credit. That has been rejected by the court. The court says, even though you have not received goods or services, even though you are not in possession of a tax invoice, the party is entitled to take credit based on the receipt voucher. This is one more thing is it is a peculiar contract. The court also took note of the fact that it is a government contract and peculiarity of the amount involved is also huge, the crore around 70 crores or so. So the court noted all the facts and then allowed the credit. So interesting judgment. Thank you very much. It may be little complex for a small businessman or those who are not familiar with GST, but more than this I cannot reduce or I cannot increase. Thank you very much. Have a great day.